Before we get started, we just want to thank Old Republic Surety for sponsoring this episode of Let's Get Surety, as well as NASBP virtual seminars. For more information on Old Republic Surety, visit www.orsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. Got with me today my co-host, Mark McCallum. Hey Mark, thanks for being on.
Absolutely. Love to be here. Thanks, Kat.
We've got a big topic to discuss today. We're talking about Executive Order number 14173 that's titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity that President Trump signed on January 21st of this year. So that's a conversation we're going to be having today.
Yeah, hot topic.
It is a hot topic. So to discuss that with us today, we have Stephen Irving, Vice Chair, Labor and Employment Practice Group, and Chair of the Occupational Health and Safety Practice Group, and partner at Peckar Abramson. Hey, Stephen, thanks for being on.
Hey, thanks for having me.
We also have with us today Tara Munder, Associate at Peckar Abramson. Thanks for being on, Tara.
Happy to be here.
So before we dive into this topic, Stephen, can you just tell us a little bit about yourself and about Peckar Abramson?
Sure. Why don't I start with Peckar Abramson, or we like to call ourselves P&A. We're a firm that's been around for 47 years now with a complete focus on the construction industry. And so we have a variety of attorneys that handle all sorts of matters focusing on the construction industry. And within that falls me and my practice area, which is labor and employment, occupational safety and health. And these are some specialties that we brought to the firm and that some other folks in some other offices have brought to the firm that we find, really complements our general construction practice. Myself, I've been practicing since 1995 and have been doing labor and employment law my whole career. In fact, I started focusing on labor and employment law while I was still in law school. And I actually initially worked for a labor union when I first got out of law school. And actually before that, then I went to work for the federal government, the U.S. Department of Labor, where I litigated matters on behalf of the government, and then left there, went to a national labor and employment firm where I focused on primarily traditional labor matters, sort of defeating union organizing drives, and then into practice here in Texas, where I eventually joined up with Peckar Abramson. We have offices in Boston, New York, New Jersey, Miami, Chicago, 3 offices here in Texas, Dallas, Houston, and Austin, as well as Los Angeles.
And maybe Washington as well?
Yes, I'm sorry. I missed Washington. I should not forget that because I actually do a fair amount of work with Washington.
Good folks there. We know some of the lawyers there.
Yeah. Well, Tara, can you tell us a little bit about yourself as well?
Yeah, absolutely. Thank you for having us on. I'm an associate attorney out of P&A's Dallas office, and I primarily handle the labor employment litigation. My background is in that as well. At my last firm, I handled a lot of discrimination and harassment cases, so this topic is something I'm definitely familiar with.
That's great. Well, to help us off, to kind of kick us off here, could you give us a little bit of an overview, Stephen, of what Executive Order 14173 is?
Sure. So the order was titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which are, a bunch of words that don't mean much without some context. And the primary thing the primary sort of, as far as specificity goes, that the order did was that it revoked an older executive order called Executive Order 11246, which required affirmative action programs or affirmative action efforts by federal contractors. But it is a bit broader than that, and it requires, or it signaled the executive branch's movements in the direction of trying to completely eliminate throughout the economy or diversity, equity, and inclusion programs, or at least what it refers to as illegal DEI programs. And so the perhaps if I can just go straight to 11246, I think
Sure.
this can help inform what the administration sees as illegal in these programs. 11246, Executive Order 11246, was an order that was signed by President Johnson in 1965. And it was intended at the time to help to enforce the Civil Rights Act of 1964, and specifically Title VII of the Civil Rights Act of 1964, which folks probably know outlawed discrimination based upon race, color, national origin, and sex. What the executive order, though, did require was that federal contractors specifically were required to have affirmative action programs, meaning not, as it is often referred to, not meaning that people had to have quotas. We're going to have this many women, this many Black folks, this many Hispanic folks, but rather that it would require efforts to include these people in your hiring, promotions, etc. And it required, so these affirmative action programs were specifically required from federal contractors. And over time, that developed to where there were sort of two different levels. There was the construction industry requirements, and there were non-construction industry requirements. The construction industry requirements were a little more lax, didn't require a complete written affirmative action plan, but it nonetheless required that federal contractors report to the federal government the makeup of their workforce. How many women, how many folks in various protected minorities were actually employed as compared to the total workforce, as compared to the workforce in any given department or group within an employer. The executive order also created an agency called the Office of Federal Contract Compliance Programs, or OFCCP, which was created to enforce Executive Order 11246. And that agency, when it would look at federal contractors' compliance with this order, would set targets. It would determine, based upon its reading of its information about the workforce in any given area, given field, what have you, it would set targets for, it would expect to see this percentage of women, this percentage of various protected minority groups. And the result was that federal contractors were compelled not to necessarily hire people who were less qualified, but to make efforts to increase the percentage of their workforce that were in those categories. And before I pass it back to you, let me also say that over time, this requirement came to also include disabilities under the Americans with Disabilities Act, and a section of the Rehabilitation Act, which was a statute that preceded the Americans with Disabilities Act. It also included veterans programs, and also includes age under the Age Discrimination and Employment Act.
Wow.
There was a lot of words to your short question, but
that seems like a lot to unwind in one new executive order. Sounds like that's a whole structure, I'm sure regulations, clauses, and all the rest that goes with that. Seeing that and what has to occur, that's got to be a little unsettling for a lot of contractors.
Yeah, I think that there is, for contractors, there is, on one hand, there is definitely relief that they don't need to be concerned about getting investigative letters from the OFCCP. Although the agency is not entirely gone, they still have mandates, statutory mandates under a veteran statute known as VEVRA, and Section 503 of the Rehabilitation Act that I mentioned that relates to disabilities. but it does take away a lot of the requirements, a lot of the concerns about being able to show that you're making the efforts as relates to sex, race, national origin, and what have you. On the other hand, though, contractors have been making efforts over the years to prove that they're in compliance with
Right.
Executive Order 11246. And now the implication of this Order 14173 is that strict compliance with 11246 may now be interpreted as discrimination,
So,
as illegal discrimination.
so when Executive Order 14173 came out, was it immediately effective? Is there a grace period, or is there a period in which it will be enforced or effective? What does that look like?
Yes, right. So the order said that contractors could keep complying with 11246 for 90
Okay.
days, which would expire on, is it April 20th? And now, what has happened since then, though, is that there is a group called the Civil Agency Acquisition Council, which is a council that is related to the General Services Administration, that creates and enforces rules related to federal acquisition. And they have now said that as of February 15th, that all enforcement of 11246 and the regulations that were created to enforce it have ceased. There's no more enforcement of it. But yeah, there is, and the other thing I would say about this change that I'm hearing from some clients is that clients are saying that they see value in having diverse workforces. Okay. And does this mean that they can't be making efforts to try and continue to employ a diverse workforce? I think the answer is no, but you do have to be careful as to how you talk about it and how you implement it. In other words, what this order very clearly states, and some other documents that have come down since then, including letters from this CAAC that I just mentioned, and a memo issued by Attorney General Bondi, it is very clear that what the administration is looking for is that you do not have policies that suggest, or practices that suggest, or that actually do discriminate against people who may be better qualified in favor of people who fall into one of the protected categories that were in 11246 or in the subsequent
Right.
orders.
So maybe a two-part question. One is, I assume that there is now a responsibility for agencies to figure out how they need to implement the executive order. So they're going to have to go through their own process in terms of implementing policies and regulations. And then in turn, contractors and others, contracting with the federal agencies, do they have affirmative actions that they must take in regard to requirements under the new Executive Order 14173?
Right. So the order itself does not specifically compel any contractors to do anything.
Okay.
It does compel federal agencies to take actions to eliminate DEI language from their policies, their websites. I just heard a few nights ago that the Defense Department has quite a number of people spending a lot of time right now. The Defense Department is massive,
Yep.
right? And there is a massive amount of information online provided by the Defense Department, and they are going through all of their material to root out language that relates in any way to DE or DEI efforts. Now, for Private employers, there's nothing in this order that compels them to do anything. But, and when I say private employers, that includes, of course, federal contractors or private employers. I think that the critical thing to be looking at is that you need to be looking at what your existing policies are, right? You need to review and revise diversity and inclusion initiatives, training programs, hiring and promotion practices, and other sorts of internal policies in order to try and strike a balance between the fact that you still have an obligation to comply with things like Title VII, the Age Discrimination and Employment Act, the Americans with Disabilities Act, and the like, and balance that with the fact that the federal government is going to be looking to make sure that you're not doing anything or saying anything that makes it appear that you intend to favor people in protected classes over folks who perhaps are maybe better qualified. This has got to include, I think, reviewing what's on your website. And, Tara and I were just discussing this earlier, that private employers are doing different things in response to this. There are a number that have gone ahead and started scrubbing or completely rehauling the language that they have on websites. Others that are resisting and are refusing to make changes. And I think what those employers would tell you is that they believe that they are in compliance with the law. Tara, do you want to take a moment to share what some of those companies are?
So some companies, they're either taking a hard stance for it or against it. So I guess for it, meaning that they would stop working on the DEI programs and start rolling back their policies they have in place to support DEI. These are big companies such as Walmart, Ford, McDonald's, Starbucks, PepsiCo, Amazon, and I'm assuming other companies as well as we go on. And there are also companies that have taken a stance that they're not going to roll back their policies. These are companies such as Costco, Delta, Apple, JP Morgan Chase, Microsoft, Patagonia. And it's not that they're opposing the order, they're just taking the stance that their existing policies are not discriminatory and they don't violate anything in this order, per se.
Right. So, I mean, those are the sort of the companies that we know of, sort of, as of print time today, right? It all may change, and certainly we can probably bet that the administration is going to have plenty to say about these companies that are saying, hey, we're not going to make changes. But what that's going to be sort of remains to be seen. I will say also, because I mentioned before that I've had clients mention that they see value in the diversity of their workforce, that federal contractors and other private employers need to think about ways to broaden recruitment efforts. Certainly, if that's a concern, find other ways to find a diverse talent pool by going to various organizations out in the world. Certainly, there is nothing about trying to find people from low income backgrounds that in any way relates to whether there's merit to hiring them. And you can look at things like universities with diverse enrollments and things like that. Beyond that, I think that people just need to keep watching the news, maybe keep a lawyer on speed dial so you see something come up and okay, what does that mean? Because regardless of where you fall on the political spectrum these days, it is coming a mile a minute. And I'm in charge of an effort in our firm where we're trying to inform construction clients about what's going on here. That's how we came to be talking about this topic. And we're sort of looking at 4 different avenues. We're looking at the DEI, we're looking at tariffs, we're looking at federal funding, and we're looking at immigration issues. And those things and they change. Or I don't know if they're changing as much as there's new information about them every day, and so it probably helps to sort of stay in touch to what's going on.
So one of the things I had read that the new executive order may contain, and particularly with respect to federal construction contractors, is there a requirement that they certify compliance with this new executive order? Is that something that may be coming down the road or is here now?
Well, that is the intent. That is one of the things that is mentioned in Executive Order 14173, okay, that new federal contracts would contain a certification that had to be made that says that you're no longer operating an illegal DEI operation. Okay. But there is some litigation, okay, about this. And there was a court entered an injunction just recently. Tara, do you want to talk about that a little bit?
Yeah, of course. And just wanted to give a little background. The executive order is just but an order. Without the enforcement element, it's just words. And right, in that enforcement, that's where it's going to be challenged by litigants in courts. And we've had challenges already. Most notably, it was a lawsuit in a Maryland district court. So there are three main issues that were challenged in that case. It was the termination provision, which basically saying that the government was going to pause or terminate its obligations or rewards under its current and existing contracts or change the obligations due to DEI programming. Okay. So the certification provision required people and government entities or private entities who contract with the federal government to certify their compliance with DE, that they're not engaging in any unlawful DEI activities. And the third one, they challenged the enforcement of the provision. Stephen, can you explain the holdings in that?
Sure. So we were just talking, you asked specifically about certifications. Yeah, and so the court enjoined the enforcement of the certification provision. So for now, that provision cannot be put in any federal contracts.
Okay. And when I hear about certifications, particularly in government contracting, I always get concerned that is potential opportunity for False Claims Act type liability. And I imagine that might have been concerns for some of the people initiating the current lawsuit or legal action.
Right. So, yes, that is a concern. And there is potential False Claims Act litigation from both the Department of Justice and from private litigants as well. The executive order specifically mentioned using the False Claims Act to enforce the order. Now, the False Claims Act, for folks that don't know, is an interesting federal statute. Most of these federal statutes that we're talking about here are within the last 60 years, and certainly all of the things that we tend to talk about these days are modern statutes. In other words, post-Depression. But the False Claims Act was actually passed in 1863 during the Civil War. And the point of it is it has both criminal penalties and potential civil penalties for misuse of federal funds. And so, yeah, for now, the ability to enforce the certification provision under the False Claims Act is not out there. But the False Claims Act, I think, is something worth employers keeping in mind, because one of the potential things that could happen with these public DEI policies that you have is that the False Claims Act allows for something called qui tam litigation. And I went to a Catholic university for law school, so we learned all the Latin terms then. What that basically means is that a person can bring a suit on behalf of the government as a whistleblower, And under some amendments to the False Claims Act that were created back in signed into law by President Reagan, individuals can potentially get a substantial payoff from money that they manage to help the government retrieve. And so to the extent that the government might be able to show that a DEI policy was discriminatory and therefore you used a false certification to gain these federal funds and perhaps could claw those funds back, private actors, and they don't have to be, and we say whistleblowers and we think of people within our companies, they don't even need to be people within our own companies. They just need to be people with some kind of knowledge, could potentially file lawsuits regarding these policies.
I find it interesting. You had talked earlier about that companies still are very interested in achieving diversity in their workforces and so forth. And yet we're also hearing that at least the intent, and we'll see how it plays out, I guess, in the legal actions about False Claims Act enforcement with respect to Executive Order 14173. Is there some uncertainty or subjectivity that if you have to certify and you believe you're adhering to the spirit, if not the letter of the executive order, but there's some wiggle room on whether your current diversity efforts then match up with your certification that you're not engaging in anything that is anti-discriminatory? Sounds like you need a good lawyer to help you kind of navigate those fine lines.
Sure. And this is an interesting conversation that I've had with clients in the past and fairly recently, because, one of the other issues that comes up here is that contracting with municipalities, state agencies, many of those sorts of contracts also require that you certify that you're in compliance with 11246.
Right.
And those contracts remain in effect. Now, we would anticipate that states are certainly not going to be going after their contractors for failing to comply with an executive order that has been revoked. But those provisions do have certifications, right? So I get calls from people who go, okay, so I've always signed yes on this, what do I do now? And yes, I think that it's always going to turn on what your good faith belief is. But I think that your good faith belief should probably involve consulting with an attorney.
It sounds like there's just a lot to unpack here with this executive order, since it's rolling back something that had been in place for quite a long time.
Sure. Absolutely.
Well, I want to thank you both for being on with us today and just helping us start to unpack these changes and how federal contractors should approach this to remain in compliance. And hopefully, everyone will keep an eye on the news and we can get you guys back to talk about other changes and what's going on as we move forward.
Yeah, be happy to do that. And Tara and I are going to be working on some follow-ups in the DEI area, and I'm also working with our DC office on some follow-ups directly in the federal contractor area as well.
So if somebody wants to get more information in that regard, particularly as this is a fast-moving area, where might they go? Is there a good spot on your website, for example?
Sure. Yeah, our website is pecklaw, PECKLAW.com, and on that site there is a resources button. You go to the resources button and look for client alerts. You'll see that we now have, I think, about a half dozen articles in our presidential action alert category. Just one so far in DEI, but we've got 2 others coming in the works. And on that site, you can also find my contact information, and folks are welcome. You can email or give me a call.
That's great. Thank you guys so much for being on with us today.
You've been listening to Let's Get Surety. Brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.